Welcome back to the Thom Hartmann Program. I'm Danielle, here with Shano, sitting in for Tom today. And as many of you know, Shano is, or was, the Supreme Court reporter over at the Talk Media News Service. So now, the new Supreme Court reporter with the best name ever, Danielle Blevins, Supreme Court reporter of Talk Media News, talkmedianews.com, at Political Brief is their Twitter, and at SCOTUS Danny, 1N, is your Twitter. Thank you so much for joining us.
Thanks for having me, Danielle.
So what happened at the court today? A big affirmative action case.
Big affirmative action case. Today, Fisher came back. For those who don't know, Fisher is the University of Texas student who was not admitted under their holistic program. And because of that, she assumed that one of those positions was hers and sued as a result. It's been going on since the Supreme Court heard this case in 2013, remanded it, vacated and remanded it, sent it back down to the Fifth Circuit, who had heard the case and said that Fisher had no recourse in this case, and they said that they should not take the university's word for it. There needed to be more proof. They believe that the University of Texas gave more proof. The Fifth Circuit came back down to that same decision, and the Supreme Court picked up the decision again. So today we're here with Fisher 2.0, and it was very dynamic, very packed courtroom as the justices heard the arguments today. Any
surprising arguments or surprising case law that maybe we wouldn't have expected in an affirmative action case?
Nothing too surprising. Just, no one's arguing the standard. Yes, strict scrutiny did apply in this case. But the thing is, with what happened when it was remanded to the Fifth Circuit basically took the University of Texas at their word. And they said, no, you can't take it at their word. We need more proof.
So the University of Texas essentially said, we didn't deny her because of her race, that
Correct.
She's just claiming that. The Fifth Circuit believed that twice now, despite her attorneys, please feel free to jump in and correct me if I misstate any of this, her attorneys claiming that it was because of race. And so the Supreme Court heard it again. It doesn't, correct me if I'm wrong, I'm not a legal scholar as you are, as Shane is. They sent it back down because there wasn't enough information. The court reached the same conclusion. How did the Supreme Court take this case back up?
They wanted to see what methods the Fifth Circuit used and what information the University of Texas now used to come to the decision that it was a need-based decision. Because with Grutter, a momentous 2003 case that did affirm affirmative action use in higher education, said that race was okay. And so they wanted to see how it was used. In Grutter, there were a lot of questions today from Chief Justice John Roberts on how long we're going to have affirmative action cases in place, because Grutter was only supposed to be for maybe 25 years, maybe depending on the circumstances. According to Texas, because of their segregated neighborhoods, their segregated high schools, and their communities as segregated as they are, they were not achieving that goal. And they needed to do something very radically different. They still used Grutter, that case, in order to shape its admissions policy. So in the University of Texas, under a case law from the Texas legislature, said that students who are in the top 10% of their high schools, whether they're majority, minority, whatever, they're going to have a spot at the University of Texas. For those who aren't in that 10%, we'll look at everything about you, your race, your gender, what you bring to this, what you would bring to your incoming class, whether your extracurricular activities, what kind of family responsibilities do you have, what's your socioeconomic background. We're going to look at everything, and race is just one of those everythings. Unlike the Michigan plan that was approved by the court in 2003, where race was a plus factor, here all the factors are equal on every ground. It's just one of the things that make you who you are, and the university gets to look at it on the same level as whether you're coming from a poorer high school or a richer background. So it just really is just one of those extra factors. Fisher's saying that because they use race, all of it's invalid.
Now, what was the response either in the courtroom or by the other attorneys, the other justices, when Robert's asking questions like this? I mean, when they've undone these policies, it's immediately or nearly immediately had the reverse effect, where it's taken diversity away from these colleges, proving that the policies were needed. How do people respond when Roberts is essentially saying, yeah, everything should be fine now? Just,
Well, I don't think that's really what he's saying, because he's in his past cases, he recognizes that discrimination is an issue, but he's saying, how long do we have to continually enforce this when is the country going to come together? And that was probably part of his frustration. From the attorney's perspective, they realized that they're only part of the community. So they have to look at the way the communities exist in the state of Texas, and this is going to affect other states as well. But within the states of Texas, how is race making up their communities? And if you have these majority and minority districts where we have, smaller schools and bigger schools and you're not getting that diversity. And they'd seen that from 1996 when a previous affirmative action case was struck down through 2004. They weren't getting the numbers. And from 2004, when the new plan was put in place to 2007, the area of the information, the data, they had seen numbers spike by 50%. Now, it's not, if you look at the raw data, it's only about 100 different, and then maybe 1% or 2% difference. But the fact that it jumped almost 50% in the number of applicants that were admitted under the holistic program shows that the university was on the right track in trying to achieve its educational goals.
Now, any indication based on the arguments used or the responses of where this may go? I mean, interjecting my opinion, based on, what happened with the Voting Rights Act, with so many of these other, civil rights, essentially, cases going the wrong way, I'm worried. Do you have anything that might, calm my worry?
Well, because the Fifth Circuit did what it did in saying that, no, we were right the first time, the university supplied its data and we approve it, it came to a court of 8 justices instead of 9. Justice Elena Kagan recused herself because of some things that she'd already done on this case when she was U.S. Solicitor General. So now there are only 8 justices who have heard this case. So say it breaks down into a 4-4 tie, even with assuming Justice Kennedy sides with the other 3 remaining justices, that would leave a 4-4 tie and a per curiam. And that would mean that there would be no binding decision from the court.
So in that case, the Fifth Circuit's decision would stand?
The Fifth Circuit's decision would stand.
So the best we can hope for at this point is that they can't agree.
Yes, and it sounded like from the arguments.
Danielle
You're
Blevins.
listening to the Thom Hartmann Program. Call 202-536-2370.
Danielle Blevins, Supreme Court reporter, Talk Media News, talkmedianews.com. Thank you, Danielle.
Thank you, Danielle.
To watch more clips from our programs, hit the Watch More Videos button over here. And please be sure to hit the handy-dandy subscribe button so you'll always be up to date. Tag, you're it.